I'm Paul Levinson, and welcome to Light On, Light Through, episode 183. The U.S. Supreme Court protects students' rights to free speech. So I wanted to rush out this new episode of Light On, Light Through to tell you about a very important and precedent-setting ruling that came down just yesterday morning from the U.S. Supreme Court, which ruled 8-1 that the Mahoney Area School District in Pennsylvania was wrong to try to punish high school student Brandy Levy for posting F school, F softball, F cheer, F everything. And I'm saying F rather than the full word because I want as many people as possible to be able to listen to this podcast, and I don't want to have it marked on iTunes and Apple and who knows where else as only available to adults. But Brandy Levy posted that on Snapchat in 2017 after she was not given a spot on her high school's cheerleading squad. So she was obviously very upset, and that's why she posted that. The Supreme Court's decisive ruling affirms that the protection that the Supreme Court gave students way back in 1969 in its Tinker, Tinker decision, where it held that students could not be prohibited from wearing black armbands to school to protest the Vietnam War. Well, this new decision makes that 1969 decision fully applicable to non-political statements made outside of the school on a social media network such as Snapchat. Now, the decision is significant for at least three reasons. One, it recognizes that obscene language is worthy of First Amendment protection. Two, it protects students from school censorship for statements made outside of the school. And three, it does not make an exception for First Amendment protection just because the communication was on the Internet. Now, the first point, I hope, should from now on be taken as a precedent not to allow the FCC, that's the Federal Communications Commission, to censure, that's C-E-N-S-U-R-E, that's severely criticize, not censor. I don't know why those two words are so close together in the English language. But the first point should from now on be taken as a precedent not to allow the FCC to censure and fine television and radio media for broadcasting obscene language, which, for example, has led CBS here in the United States to lacerate rap and hip-hop performances with bleeps during the Grammys every single year. And yesterday's decision can also be seen as a reversal of the Supreme Court's unfortunate, misguided decision back in 1978 in the FCC versus Pacifica case. That decision upheld the FCC's right to censure and threaten WBAI radio for broadcasting George Carlin's hilarious 7 Dirty Word routine. Meanwhile, the second and third points that I mentioned in effect reverse the Supreme Court's 2011 decision to not even consider Avery Donninger's appeal of the 2008 U.S. Court of Appeals Second Circuit decision. That was made by a panel, by the way, that included Judge Sonia Sotomayor before she was appointed to the U.S. Supreme Court. And the Supreme Court back in 2011 refused to even consider Avery Donninger's appeal of that U.S. Court of Appeals Second Circuit decision, which said that Donninger's high school was entitled to punish her after she called her school officials, quote, douchebags, unquote, on her Live Journal blog. And in fact, I interviewed Avery Donninger and her mother, Lauren Donninger, back in 2009 about that decision. And there'll be a link to that on the show notes for this episode, because that interview back in 2009 was indeed an episode of Light On, Light Through. But I'm really glad to say that now, just under a decade later, the Supreme Court, including Sotomayor, has spoken clearly and overwhelmingly on the excesses of school officials who, frankly, could use an education themselves on the First Amendment. I don't know where they get these people and why they're appointed to these jobs where they have such control over our children. Frankly, they should learn a little something about the First Amendment or resign and, I don't know, take a job as a gardener or something where it doesn't matter if they try to restrict the rights of roses and other plants to communicate. Although I wouldn't even be too happy about that. Now, I should mention that the one dissenter in yesterday's momentous decision was Clarence Thomas. He amazingly found the court's decision, and I'll quote here, untethered from anything stable, close quote. The First Amendment couldn't be a more reliable post on which to tether our freedoms, Justice Thomas. Now, Clarence Thomas, of course, was appointed by George H.W. Bush back in 1991. In other words, that means that every single one of Trump's appointees did do the right thing in this hallmark case and the decision that came down yesterday. And this demonstrates once again the independence of our judiciary, which more often than not over the years continues to be one of the pillars of our freedom and our democracy.
The Light on Light Through podcast.
Well, I hope you enjoyed that analysis of yesterday's important Supreme Court decision. You will find also on the show notes a link to the actual Supreme Court decision. So if you're interested, just go to lightonlightthrough.com and you'll see in the show notes a link to the Supreme Court decision. In any case, I'll be back here soon with another episode of Light On, Light Through. Could be more political commentary, could be another interview, could be a review of a science fiction movie or television series, who knows. In the meantime, stay safe, stay sound, and enjoy.
Athens, 2042 AD. She ripped the paper in half, then ripped the halves, then ripped what was left again into bits and pieces of history that could have been. Sierra Waters had read once that, years ago, it was thought that men made love for the thrill, while women made love for the sense of connection it gave them.
Curled Up with a Good Book says, Sierra Waters is sexy as hell. You can find out more about The Plot to Save Socrates by Paul Levinson at theplot2savesocrates.com.
Paul Levinson's Silk Code, about an ancient biotech war raging on in secret for centuries.